This is a messy commoner. Listen up. This happens a lot. Let's go. Welcome to the Court of My Public Opinion. This is Attorney Ali Booker. You already know what time it is. You send me your question, I bring it to the Court of My Public Opinion, I give you my answer. Although I am a professional and a good one, please don't take everything that I say as legal advice, because you got to make sure that it fits your specific case, okay? So don't sue me. This is not legal advice straight to you. This is to the person they wrote, okay? Let's go. If something happens to one of the two persons named listed on the title, who gets the car? My mother-in-law was gifted a car, and the title is underneath her name. My husband wants to add his name to the title. If something happens to her, will he get the car or will her spouse get it? Wow. Because it was a gift to your mother, somebody gifted your mother the car, her spouse is not entitled to it unless she wills it to that spouse or unless something happens to the mom. And at the point in which something happens to the mom, separate property, all the property that she has is going to get put in the same pot, because we're not talking about community and separate. The reason that I was acknowledging that it's not her husband's is because it was a gift. So he has absolutely no right to the property at all, which is why your husband's trying to step in and get on the title, so that if something happens to his mom, he can get the car free and clear without the husband dipping his hand in the pot. That's what y'all need to do. She needs to go ahead and if that's what she wants, she needs to let her son get on that title. And then if something happens to the mother, yes, that car is going to go to the son. Because what happens is, mom's interest is only what she has. If she titles that car straight to her son, then she doesn't own the car. But if she owns the car and she passes over, it's going to go half to her spouse, half to her heirs. Half to her spouse, half to her heirs. And what will happen is, depending on how many brothers and sisters your husband has, they'll get half, 50% of the car. And then her spouse is going to get the other 50%. When this happens, what happens is people fight. And if one side doesn't buy the other out, you're going to have to go to court, file a suit and partition, force a sale, and split the proceeds. So please, the mother probably needs to will the strike that. The mother probably needs to title the entire vehicle to your husband, to her son, to pull herself off of it. Do a gift, okay? Do consideration of $10 and give it to your son. It's going to keep it away from out of your hands too, because at that point it's a gift from his mother to him, and you won't be getting it, in a divorce if that is to occur. But you didn't go that far, so I'm going to back it up, and I'm going to only answer the question that you asked. Yes, ma'am. She needs to transfer title to her son, not add him to. Because the situation that they're trying to avoid, you'll be right back in that situation if he just adds himself to the title. You'll be at the same situation with a different percentage. Because what will happen is, mom's percent will go down to 50%, and then when she passes, 25% of that car will go to the husband, the other 25% to the issue, meaning your husband or other spouses. So it'll break it up a little bit. Just send the whole thing to the husband, and then he'll let the mom keep it while she's alive, and then when something happens, if something is to occur, he'll get it free and clear without all the mess. Next case.
Sitting here behind these walls, think it's time I made that call. I'm locked up and facing charges. Who gon' fight these cases for me? I called Booker Law Firm, they got the job done. They were right there for me.
For more information, contact the Booker Law Firm at 713-292-2225 or visit the website at bookerlawfirm.com.